protect society, whether you're here undocumented or documented. It takes out the whole section of rebuttable presumption and the secured bail. So in other words, what this amendment is offering is that we keep the status quo on the existing statutes, which this bill does not invalidate, by the way, but it basically keeps it just where it's at right now, where folks can get out on bail, continue to commit crimes. I think that it's really important to realize that the purpose behind this bill is to focus on the criminal element within the undocumented community. This provision, this amendment here, will gut the provision of the bill that will allow and enable a judge to keep someone incarcerated based on the criteria we put here. I encourage you all to please vote no on this.
Representative Harris, you're recognized on the amendment.
Thank you, Mr. Chair. It's also helpful to note that a lot of these people we're talking about are parents of American children. But I wondered if it'd be possible to get a reaction from a jury chaplain conducting a Greensboro analysis on impact. I would like to get the perspective of the correction attorney on the specific amendment. Is that possible?
If we're going to take a vote by 144, I guess we can recognize him for a minute. Is it possible to summarize your reaction in a minute, sir?
Yes, Your Honor.
All right.
Well, good afternoon. Good afternoon. My comment today would be that this bill is unnecessary, and specifically this part is unnecessary because, as Judge John had said, judges are dealing with bond issues in this manner without the necessity of this bill. The larger point I would make is that this is an effort to have the state of North Carolina enforce immigration laws that are federal responsibility. And if there's a problem here, a symptom, the cause of that problem is in the structure of federal immigration law, which is the responsibility of the federal government. And the people that are working on that solution right now include the junior senator from North Carolina, Tom Tillis. And I would suggest that everybody in this room would be spending their time in a much more effective manner to be in touch with Senator Tillis and encourage him in every way possible to pass the legislation he's working on. But again, my point here is I believe this is unnecessary.
Thank you. You may respond.
Senator Tillis and I worked on this bill together back in 2013. Senator Tillis was a very strong supporter of this bill. I recently spoke to one of his liaisons here in North Carolina and provided them with some information that helped formulate this bill. I'm pretty well aware of what his position is on this. If the bill were unnecessary, I wouldn't have wasted 4 years on it. I believe we need this. We don't need that amendment.
Further discussion and debate on the amendment. Representative Michaud.
This obviates my problem altogether with the amendment here, because it gives have an intermediary in there who knows what you don't leave it up to the defendant. That's the defendant's one. You leave it up to an arbitrator. Leave it up to an arbitrator who is the judge to make the determination whether or not an individual is claimed.
Representative John, you're recognized the second time on the amendment.
Thank you, sir. And by the way, I wanted to thank Representative Moore for taking the time to discuss this amendment. I appreciate it. I just want to simply reiterate, this amendment requires the judge in all cases, not simply the limited felony assessment in the bill, to consider the specified factors. We've all opinion that you must consider these factors in setting conditions of pretrial release. I respectfully suggest that should be any concerns about these factors coming before the court and the court being aware of them.
Further discussion and debate on the amendment. Seeing none, all in favor of the amendment, say aye.
Aye.
All opposed, no. No. The chair is not certain of the outcome, so let's show hands. All in favor of the amendment, raise your hand. 6 in favor, all opposed. 5, but the chair will vote no, so the amendment ties 6-6. Now, Representative Hall, you're recognized for a motion.
Mr. Chairman, I do this for table report, PCS, House Bill 63, and additional proposal finance committee.
With the, as amendment. Representative Hall has moved adoption of the PCS as amendment with amendments rolled into a new PCS. That PCS be given a favorable report. Unfavorable is the original with a serial referral to Appropriations and Finance. Representative Harrison, you're recognized on the motion.
Thank you, Mr. Chair, and I want to speak against the amendment, but I think it's unfortunate we haven't really heard from the cities or the counties about how they feel about the bill, since it seems to add a burden on law enforcement at both levels. Is it possible to have them speak for a minute?
Well, we opened the committee to anyone who wanted to speak for 2 meetings. I do regret that we keep having session at 2, which takes away an hour of the committee's time, and we do have other bills building up in the committee's inventory, so it's just necessary to move this at this point, but you're recognized to make any point you want to regarding the city.
Well, I do believe that we are imposing a burden, that we're not providing the training or the funding for what will be a pretty substantial burden on law enforcement at the city and county level. I'm sorry that Representative John's amendment didn't pass, because I do think this bill is constitutionally suspect. There, as I understand it, in Maricopa County, the sheriff no longer holds individuals with an ICE detainer. Miami, Florida was practiced with rule unconstitutional. I think we're setting this up for another expensive legal bill. And this is the last subsequent House committee that's going to be hearing this. Preparations and financial, just going to be dealing with the money aspects of it. I just want to remind you, we're talking about parents of American children, and I just don't want to avoid this, the signal this bill sends about what's going on. So I'm going to urge you all to vote no.
Representative Warren, you're recognized to respond.
This bill doesn't seek to require our law enforcement to do anything in terms of enforcing federal immigration law. This bill simply says, don't go in conflict with it. Go about your business, do your job, and don't go in conflict. It tells our elected officials in the counties and the municipalities not to go in conflict with federal immigration law. It does not require additional training to do their jobs. They're doing an excellent job out there now. This will seek some clarity for them in this particular regard. This bill does not seek to tear families apart. It's all the provisions in this bill are addressed at the criminal element within our society and within the undocumented society. We're not dragging families apart, and I think that's a mischaracterization of the bill, and certainly demonstrates a lack of understanding of the provisions in it.
Representative John.
Thank you, Mr. Chair. As to the comments by the bill sponsor directed at the immigrant community, let me suggest a scenario that might well transpire under this law as proposed. We have 2 individuals, 24 and 22-year-old brothers, North Carolinians, born and bred. The younger, 22-year-old, has lost his driver's license. Had his driver's license revoked for excessive speeding charges, any number of speeding charges. Does not have his driver's license. For one reason or another, he approaches his 24-year-old brother and said, "Let me use your driver's license. I need to drive, get in the club, whatever it might be." If the 24-year-old brother gives the 22-year-old brother his driver's license to use, and it's the 22-year-old is subsequently stopped, arrested, presents the brother's driver's license. Under that scenario, the 24-year-old brother would be guilty of a violation of 20-30.237 Marines 2 on page 2. Would be guilty of a Class G felony, punishable by up to 47 months in prison. Whereas the 22-year-old would be guilty of a violation of 14-100.1, which is a Class 1 misdemeanor, punishable by 120 days in prison. We talked about unintended consequences, I believe, in one of the meetings here. That strikes me as perhaps an unintended consequence.
Representative Warren.
To the contrary, Judge John, That's exactly the law. What the scenario you pointed out, what you didn't emphasize, was in that particular case, the 24-year-old deliberately determined himself to break the law. And there's a consequence for breaking the law. And it's about time we quit worrying about the consequence and worry and concentrate more on obeying the law. So I'm sure that wasn't the case that you, or the point you were trying to make, but the fact is, the 21 or 22-year-old could have just as easily asked his brother for a ride, asked a friend for a ride, called Uber, walked, but they deliberately broke the law, and there's a consequence, and you knew that being the judge. I ask for your support on this bill, please.
Further discussion or debate on President Hall's motion? Hearing none, all in favor of giving the PCS a favorable report, signify by saying aye.
Aye.
All opposed, no?
No.
The chair can't determine, we'll have a show of hands, all in favor, signify by saying, or, all in favor, raise your hands. All opposed? The bill passes by 6-5 and gets a favorable result. We do have 5 more minutes left, so Representative Stevens, do you want to get started on the next bill, the House Bill 123, registration discretionary for sexual battery? Representative Stevens.
Thank you, Mr. Chair, and when we initially brought this out of the Courts Commission, we didn't anticipate there would be much objection to it. The last day or so, I finally heard some objection, and so I appreciate the opportunity to present it, that way we can invite comment.